Mr. Lee remains wrongfully imprisoned today because of a grave miscarriage of justice, made possible because of an unethical cover-up scheme orchestrated by the University of Illinois Chicago Forensic Testing Lab. As early as 2021, this lab began to suspect that its THC test was not rendering accurate results. Then, in March of 2024, this lab became conclusively aware through failed validation experiments that its THC test, which was supposed to be able to determine levels of illegal THC in a person's bloodstream, could not actually differentiate between legal hemp, also known as Delta-8, and illegal THC, also known as Delta-9. Because of this fatal flaw, each of the lab's reported measurements of illegal THC in a suspect's system were instead the combined total of legal Delta-8 and illegal Delta-9 that the suspect had consumed. But the lab failed to ensure the accuracy of its tests and hid this defect from the public, and thus continued to allow actually innocent persons to be convicted under false pretenses. Corey Lee is one of those wrongfully convicted persons. He was arrested after falling asleep at the wheel and running over two pedestrians, and ultimately convicted of aggravated driving under the influence of cannabis, resulting in
Counsel, excuse me, good morning.
Good morning.
We have a lot of issues to cover this morning, and I had some questions.
Certainly.
Your client retained counsel in July 29th, and at that time, counsel were aware of this issue that you've just been talking about with the lab, correct?
Yes, correct.
And they nevertheless filed the post-conviction petition late. If this had been a personal injury suit, for example, and we knew, or the attorneys knew, that the statute of limitations was going to expire in 29 days, they would certainly make every effort to get a timely complaint on file, would they not?
They would, yes, that is correct.
But in this case, that is not what happened. The post-conviction petition was late, and they allowed the deadline to pass, taking 3 months to file something on behalf of the defendant. How, under these circumstances, can we say that those actions were anything but reckless? And this, of course, relates to the issue of culpable negligence.
Yes, yes. Well, first, Your Honor, I think what we need to turn to is the fact that in the petition itself, counsel set out a detailed timeline explaining exactly why he was unable to submit the petition at the actual due date, which included, sorry, did you have a question?
Well, I was going to let you finish your sentence. Go ahead.
Okay.
Yes, I do, but finish your sentence.
Which included the fact that, first, as we just discussed, the ongoing cover-up did not start to unravel until May of 2024. Then, trial counsel was actually unable to provide Mr. Lee's full case file to post-conviction counsel until August of 2024. And that was
But we don't know that trial counsel was unable to do that. We don't know any other steps that counsel for the defendant took with respect to obtaining it, what the reason was that it was turned over on that date. There are no details that are given here or are part of the record.
There's no details, but there is an affidavit saying as much. And because it is the second stage, that does need to be taken as true, as a well-pled affidavit. So because of that, at this stage, we are taking as true that trial counsel was unable to provide Mr. Lee's case file to post-conviction counsel until that date, because he did provide that signed and notarized affidavit.
Well, it seems, does it not, that the strategy of these attorneys was to really, since they knew all this information that they had through reports, through conversations with people at the lab, they had the information. Their strategy, it appears, was to file it late, ask forgiveness, rather than permission, perhaps, to add more detail at a later time. Again, how is this not reckless on their part?
Well, Your Honor, what you just pointed out actually points to another problem that counsel could have run into had they filed an insufficient and incomplete petition ahead of the deadline. The Act does not contemplate more than one filing at the first stage. So here, it is not guaranteed that the judge would have allowed an incomplete filing and a later supplementation at the first stage. So there is a very real chance, had counsel filed an insufficient, incomplete, factually void petition prior to the deadline, that is simply what he would have had to stand on. And that would have not constituted reasonable or effective assistance of counsel. So here we have the confines of the Act, and we also do have the, as we were talking about, culpable negligence standard here, which is the only way in which the late filing should not be considered. As you discussed, culpable negligence is akin to recklessness or a conscious disregard. And here we do have this detailed timeline showing why it would not have been possible earlier. So if it wasn't possible earlier, that is not a disregard, that's an impossibility. And that is exactly what the safety valve is for in this Act.
But counsel, you seem to be suggesting that that it was either, completely inadequate or complete. That either it was filed early and inadequately and lacking in any merit, or it could have been filed late and then would have been complete. And it was very complete. But isn't there a middle ground here? Didn't they have enough to file a plausible petition with what they knew about what was going on at the lab by the applicable deadline?
Well, Your Honor, there could be a middle ground in a certain case, but here there was not, because the scientific report was not done. Without the science, that is the heart of the claim here. The scientific report by the outside scientist who was able to describe and explain how the test here was not accurate. Without that, there is nothing except perhaps the words of an attorney who does not even specialize in this area. So that was necessary before non-frivolous filing could be completed.
But counsel,
go ahead, Justice Lehner.
Along those same lines, though, when we're talking about, culpable negligence and as Justice Zinoff has correctly pointed out, making that akin to recklessness, wouldn't they have been in a better position to have attempted the filing? And then if it was dismissed, as you're suggesting, with that later part, then they can say, hey, we made every effort. We needed more time to do this. Wouldn't that have strengthened that argument that they weren't reckless?
It perhaps could have strengthened an argument that, or it could have presented that same argument, but I do not feel that it would have strengthened that argument because, again, as we talked about earlier, there is not a guarantee for a second filing at the first stage. So that would really be a gamble on counsel's end. What we have here is a situation where, because of the timing of this cover-up and this whole scheme, counsel really only had two gambles at his disposal. One of those was to file an insufficient petition without the scientific report and without the scientific findings. And the other was to work as quickly as possible, detail a timeline, get affidavits, and then explain to the court why this was late and why it was not culpably negligent tardiness. So really there was two gambles here, and there wasn't a great choice for counsel to make, and counsel did the best under the circumstances. So moving to our second argument, because even if this court does find that culpable negligence prevents consideration of the due process claim, we still have Mr. Lee's actual innocence claim. So here, the key issue was whether Mr. Lee had at least 5 nanograms per milliliter of Delta-9 in his blood at the time of the accident. And as we've previously discussed, it has since been irrefutably shown that the blood test responsible for Mr. Lee's conviction could not actually differentiate between illegal Delta-9 and legal hemp, and that this information could not have been discovered earlier because of the lab's elaborate cover-up scheme.
I'm sorry, you said illegal 9 and 8?
Yes, so Delta-9.
All right, I thought I heard you say 10, but maybe I misheard you.
No,
Okay,
and
you
I
meant,
apologize if I misspoke, Your Honor.
maybe I misheard you, but we're talking about Delta-9 and Delta-8.
Yes, that is
Correct?
correct.
Okay, all right. So I had a question on this issue. Defendant's theory basically was that Delta-8 could have been in his blood because it was a commonly encountered isomer in early 2018 that could have been ingested inadvertently, and since it was a compound commonly found in cannabis material at the time. And for that, he relied on an article that in essence said that although Delta-8 is typically found in low concentrations in cannabis plants, some studies show that it could account for up to 10% of the total THC content in fresh marijuana samples. So my question is, why really is that statistic relevant here when we know that the UIC lab did not analyze a fresh marijuana sample rather than a blood sample that was taken 27 hours after the defendant said he last smoked cannabis, and where the defendant really provided no evidence, at least I haven't seen any in the record, regarding how a person's body would metabolize Delta-8 versus Delta-9.
So to the first part of your question, there are parts of the scientific report, and I do not have it in front of me, so I cannot point to a specific page number, but there are parts of the scientific report that was attached that do explain that when Delta-8 and Delta-9 are both present, as they usually are in cannabis plants, that those do both make it into one's bloodstream. And as to your second point about that, the fact that we're not sure how much was in his bloodstream is exactly why we need a third stage evidentiary hearing, because this test was supposed to be able to differentiate the amounts in the bloodstream, Delta-8 and Delta-9, and it could not do so. That uncertainty that you point to, taken alongside the fact that, as you also point out, there is Delta-8 naturally occurring in all cannabis plants, and also considered alongside the fact that there are now extremely sophisticated processes through which creators or manufacturers or what have you of marijuana can add additional Delta-8 into their products and make it 50, 60, 70% Delta-8. We simply don't know. Then, because we don't know that, that is a factual question to be determined at a third stage evidentiary hearing where the record can be developed for that purpose.
But it's not alleged to be true. It's stated that we don't know if it's true.
Well, it is alleged to be true that there was some appreciable amount of Delta-8 in his system. What is not alleged is that exact amount, because that's simply impossible to know without a third stage evidentiary hearing. So that's what we need to find out what the exact amount was, because the test was unreliable. And to
But with the material that you submitted, and Justice Zinoff referenced the article, as far as what's before this court, it seems to me what's been presented to us would be the maximum, which, you indicated some studies have shown that Delta-8 THC may account for up to 10%. So it seems what's before us, as far as the factual basis alleged, would be a maximum of 10%. I know you're suggesting there may be more information you didn't know, but as far as what you presented and what they presented as part of the petition, is there anything more than 10% that's been submitted?
Yes, Your Honor. So actually in that scientific article, and I apologize if I wasn't clear, the scientific article specifically states that it is very possible for there to be more than 10%, and that is included in the record. So it states that through synthetic processes, that amount can be altered basically at the will of the person altering it. So that number could vary anywhere from the minimum to nearly 100%. And to put this in further perspective, the newly discovered evidence also showed that the test had a nearly 20% rate of mathematical uncertainty. And then we have the fact that the supposed blank ran before Mr. Lee's test, which is supposed to be blank to show no contamination, came up showing delta 9. So
over the limit. I mean, that's the problem here. If we do the math, and I'm not great at math here, but even if we take the 10% or the 20%, we still come up with, in the one case with the 10%, 5.25, and with the 20%, we are still over the legal threshold. So I don't see how that gets us to actual innocence, how the trial court was wrong on this.
So, Your Honor, I actually would present a little bit of different math here. So because there's a 20% mathematical uncertainty rate to the test, that means that Mr. Lee could have had as little as 5.2 nanograms per milliliter of psychoactive isomers in his bloodstream at the time of the incident. And then we have the fact added in that the blank showed that some of that delta 9 did not actually come from his system. Taking that into consideration alongside the fact that, again, as has been shown in the record, delta 8 is present in nearly all THC products, the product that Mr. Lee consumed would have only needed to contain enough delta 8 to account for approximately, and possibly less because of the blank again, but approximately 0.2 nanograms per milliliter of the psychoactive isomers found in his bloodstream. And a nanogram is just 1/1000th of a gram. So taking even the smallest number, the smallest percentage of delta 8 that was found in these plants throughout these studies, that would render him innocent.
But we have no idea what he ingested. I mean, you talk in your brief also about a synthetic product, or there are synthetic alterations, but there's no evidence given in any of these petitions here that the defendant consumed a product, let's say, that was fortified with, or synthetically fortified with delta 8.
Well, what
So
was
there's just not the detail and the information connecting all of this to the defendant and what actually happened here.
Well, Your Honor, what was asserted in the petition was that he consumed something that had an appreciable amount of delta 8. At the end, that is what matters. It doesn't matter if it came from a synthetic process. It doesn't matter if it was naturally occurring in that particular product. What matters is that the assertion here is that he consumed something with an appreciable amount of delta 8. And these factual questions that you get to are exactly what are supposed to be discussed and discovered at a third stage evidentiary hearing. He has well-pled facts here about what he consumed in tandem with the likelihood that what he consumed contains delta 8. And because those need to be taken as true at this stage, that is enough to necessitate that extra evidentiary, third stage evidentiary hearing so that we can be certain that about the conviction. Otherwise, there is, as this panel has acknowledged, there is uncertainty that he was above the legal limit. If there is that uncertainty, there needs to be a third stage evidentiary hearing.
When you say this panel, I don't think, at least in my questioning, haven't acknowledged that. In fact, I based some of the questions on the opposite, that while there was uncertainty involved, it did not get him below the legal limit. But let me pivot for a minute and talk about this system blank, which in essence, I believe is a control test. The evidentiary support here that we have for defendant's claims that relate to his own testing really came from and I'm sorry, our time is up, but let me finish the question, let you answer. As I said, there's a lot to cover here. His records reflected contamination in the system blank. However, that really came from his attorney's report of what a UIC lab employee told him. Now, I guess the strict rules of evidence don't really apply necessarily here, but what are we to make of a lawyer putting himself in the position of a witness, reporting his understanding of what someone else in a lab told him about highly technical matters, and how does that constitute a showing of actual innocence?
Well, Your Honor, what I would say to that is in the record, there is also a graph that was provided to him by the lab showing the amount that was in the blank. So it is not just his words there. He does have a graph as well in the exhibits. But also, I think all of this points to, again, why there is a need for a third stage evidentiary hearing. Also, briefly to clarify my earlier comment, when I said the uncertainty that this court expressed, I was expressly referring to your comment about how we are not sure how Delta 8 is metabolized in the bloodstream and how that could have affected the levels here. And because we don't know that, I am saying that it is necessary to go to a third stage evidentiary hearing so we can get that proper information.
Right, and my point was, and I think you accurately rephrased what I had said, but my point was, we don't know that from the defendant, and one would have expected, or I would, as a panel member here, would have expected it as part of what the defendant presented to convince us that we need a third stage hearing. But you'll have additional time on rebuttal. Justice Lannert or Justice Doherty, do you have any other questions of Ms. Yesman now? Okay, thank you very much.
Thank you.
All right, Ms. Brooks.
Thank you, Your Honors. May it please the court and counsel. Hiring counsel does not relieve the defendant of culpable negligence in this situation. And so I think a lot of the gist of the argument here was from the defense was that the counsel faced this sort of like predicament of whether to file what she characterizes as an insufficient petition that would have been dismissed at the first stage versus the fully complete petition that was ultimately filed late. Although here, the defendant, who has the burden of complying with the statute of limitations, could have filed a pro se petition with limited detail, and that would be satisfactory under the first stage. You do not need to file a complete petition at the first stage because the law recognizes that pro se defendants are not always going to be able to file a complete claim at the first stage. So that's not a requirement. And this could have passed first stage review easily with limited detail.
Is that a
Well, I mean, he
realistic
did-
option?
Go ahead, I was going to ask.
Yeah.
For a defendant who is represented by counsel, we've got cases talking about courts being allowed to ignore pleadings filed by folks who are not truly pro se.
Well, there's no pending trial or anything in this case.
There's
He
nothing
could have
of
filed
record.
right.
There's
He could
nothing
have
of
filed.
record, but you're expecting a person who is not skilled in law to ignore what his attorneys may be saying and to proceed out on his own. That just doesn't sound realistic.
Well, the burden now is under the statute is on the defendant to comply with the statute of limitations, and he does have the option. That's why I just mentioned it is an option to comply with the statute of limitations. If I was in his position, you would be looking at the impending statute of limitations and you think, I've got to get something on file, and it doesn't have to be a complete petition. And relying on his counsel doesn't absolve him of the lack of culpable negligence in this situation. So the counsel could even have filed a first stage petition with limited detail, and it would have been subject to the same first stage standard of review. Just because it's filed by counsel doesn't mean it's subject to a second stage pleading standard. It's a first stage pleading standard. So counsel could have even have done it too. But my point is it's still the defendant's primary responsibility. But either way, this court should not approve the idea of essentially brazenly violating a statute of limitations in order to file a fully complete first stage claim when it's not necessary to do so at the first stage. And I think the defendant's argument is, well, there's no guarantee of giving a second crack at filing at the first stage. Well, he gets a opportunity, a guaranteed opportunity to amend his petition at the second stage once it passed first stage review. And I don't think there's any serious risk of it getting dismissed at the first stage when he could have easily supported the petition with a sufficient evidentiary material to show that there was an issue at the lab. I mean, there was already news reports and everything about the cover up at the lab. And to say that his case arguably, because that's the standard at the first stage, his case arguably fell within the issues, the Brady issue, for example, or the actual innocence claims would have been arguable at the first stage, improperly supported without requiring complete evidentiary support. There would have been at least a necessary bare minimum of evidentiary support, but that could have easily been attached in the time allotted. And I'm not saying this was easy for the defense because the time frames were relatively short due to the cover up of the lab, and that's definitely not the defendant's fault. But this court should not approve what the defense ultimately did here, which is to brazenly violate the statute of limitations or to file a unnecessarily complete claim at the first stage. So that's kind of that procedure should not be approved, but there's no really necessary to resolve that question because the state had argued that the defendant's claim that is subject to the statute of limitations, as is the Brady claim, because the actual innocence claim is not subject to this limitation, but at least the other claim is Brady, because the evidence here, the undisclosed information was not material for purposes of Brady. Therefore, he's not. Well, he's asking for a direct remand for third stage evidentiary hearing, but the state's position is that this was properly dismissed because it failed to make a showing at the second stage, a substantial showing of a constitutional violation that is the Brady claim, the due process claim, that the undisclosed information was not material. And the reason why is because what the judges ruled is that there's no allegation even here that the defendant consumed a product that had THC. And because the defendant's DUI occurred on March 26, 2018, and the defense here today is not telling us that the federal farm bill was approved December 20th, 2018. That is many months later. So the sort of the federal law that gave the genesis to this whole industry of THC-8 products, the Delta-8 products, didn't even happen until many months after the defense DUI. So it's not even conceivable that he was consuming some sort of legal THC-8 product, which wasn't even in existence in March of 2018 because the federal farm bill wasn't even approved until December of 2018. So
But
it's
we
really,
know, excuse me, but we know that, I mean, that the defendant cited this article that the Delta-8 THC can account for up to, I guess the article reflected 10% of the total content in some fresh marijuana samples. We know that this defendant was a heavy cannabis smoker before this incident. So why does that not create a factual issue as to whether or not these toxicology results could have been skewed by the presence of Delta-8?
well, the part of the record that state cites on 938 to 939 shows that the proportion of Delta-8 THC in plant-based cannabis is actually 0.1% to 2%. And even if it was 10%, if you take that off of 6.5, it's still above the 5 standard in the statute. So this case was presented on the basis of a stipulation, and the defendant stipulated that all instruments were working properly and the testing performed was generally accepted in the scientific community. Now, that stipulation does not prevent him from raising a Brady claim, but it's definitely going to make it harder for him to press his actual innocence claim, because in a case like this, where it seems like the defendant factually, at least as a factual matter, was pleading guilty. I mean, he preserved the constitutional issue. He believed the statute violated due process, substantive due process, that it was punishing him essentially for driving without actual impairment on the basis of presumed impairment, and he lost that constitutional issue, but at least he preserved it. So it's not a straight guilty plea, but at least factually it's akin to what's like a guilty plea. And essentially when you make after a guilty plea, if you claimed actual innocence, you have you're not precluded from claiming actual innocence in a post-conviction petition, but it's much harder. Now you have to show clearly and convincingly that the trial that you would get then after a guilty plea would probably result in acquittal, rather than just probably result in acquittal. You have to make a clear and convincing showing of it. So I think
Well, but no, wait, let me stop you there. Clear and convincing is based on Reed. That was based on a guilty plea. We don't have a guilty plea here. We had a stipulated bench trial. So I believe, it's not Johnson, but Robinson, I believe, is the case that I think really pertains rather than a higher standard of clear and convincing.
Well, I understand the distinction is correct, but the state is saying, at least preserving the argument, that as a matter of fact, he was not contesting his guilt. He was only saying that I'm guilty, yes, but the statute's unconstitutional is essentially what he was doing. And if he's factually guilty, and the only question is whether the statute's unconstitutional, then when he comes back in a post-conviction petition and says, actually, I'm innocent, I think the fact that his stipulation, like the fact that the instruments were working properly and the testing performed was generally accepted in the scientific community, makes it harder for him to press it. Now, it's not necessary for the state to hold him to this sort of clear and convincing standard, because I think he still fails under his facts. He's got a square peg case here. His case came before the rise of THC-8, Delta-8 products that would have made it really hard to differentiate. This case, the lab lacked the ability to differentiate THC-8, which matters if he had actually consumed a THC-8 product after it became widely available with the federal farm bill approval. But he didn't do so. He's a square peg case. He's trying to fit into that hole with his square peg, and it isn't going to work because, like the judge said, he's like, you didn't even avert that you took a Delta-8 product, and how could he? Because it wasn't even available back in March 2018. So he's got to rely on these sort of arguments that actually sound a lot just like reasonable doubt. And you can't claim actual innocence on the basis of saying that, well, actually, maybe there was a reasonable doubt here. The uncertainty that the defense is relying on is not actual innocence.
Right, but we're not really talking about necessarily reasonable doubt. If we go back to looking at some of the arguments that opposing counsel made with respect to why we need a third stage hearing, she pointed out certainly the problem with the system blank, the Delta-8, Delta-9, indicating also that we needed a third stage hearing, or a third stage hearing is needed here to develop some of these facts and how they related to this defendant. Why is she not correct?
Because she hasn't,
Go ahead.
right, she hasn't adequately pleaded the standard of actual innocence to bypass the second stage. The third stage is only to prove adequate claims, legally adequate claims. And here the claims are not legally adequate, so they don't pass second stage review. And the idea that there might be a problem with the blank, for example, that merely gets to the possibility of reasonable doubt in a case where the defendant stipulated his guilt, essentially. So that's why it's not an actual innocence case, because not only does he have no actual claim of actual innocence, that he's trying to derive a problem with the lab that deals with other cases, not his case, but other cases. Other people might get relief under the same issue because they came after the Farm Bill. They actually can say, yeah, I took gummies or something and I had THC and that skewed my result. And this same lab at the University of Illinois, Chicago tested my blood and found it was 5.3. That person's going to get relief. This defendant is not in that situation. That's why this is an honorable attempt to try to glom onto some other cause, but this is not a case that this lab, with its admitted deficiency and ability to differentiate Delta-8, didn't make any difference in this defendant's case when the DUI was actually in March 2018 before the federal Farm Bill. So it didn't really matter back then. It became important later when people started taking Delta-8 products, but it didn't matter for this defendant. And that's why he properly lost his post-conviction petition. So
let me go back a minute to the question of culpable negligence. If we look at the record, the trial court, I believe, used the word incredulous when talking about defendant's trial counsel not immediately turning over his file to post-conviction counsel, knowing that defendant was running up against this deadline. But doesn't this amount to a credibility determination that the trial court was making? And of course, we know that should not be done at the second stage. So if we put aside, if this were a credibility determination, really, what other basis is there to affirm the trial court's decision and determination that the initial petition was not timely?
Well, the case cited Stoker, where it says from 2008, where it says defendant hired counsel to assist him, does not relieve him of culpable negligence for the late filing. So under Lander 2005, Illinois Supreme Court, the sole obligation of knowing the time requirements remains with the defendant. So the fact that the defendant had everything he needed to file a adequate first stage petition and just did not do so, the fact that he hired counsel to help him doesn't absolve him of complying with the deadline. So a lot of people get the counsel after they file the first stage, and then they file the pro se petition, advance to the second stage, and counsel gets appointed, or they can hire counsel of choice, and then they get an amendment. Well, he could have done that, but he chose to hire counsel and rely on them, and they made a very poor decision to try to comply, or to file a entirely complete petition at the first stage, like a petition that they didn't intend to need to amend. I mean, it's like they have a statute of limitations. You just cannot approve a procedure where you know you have a statute of limitations and you just want to file a totally complete, no necessary to amend, unnecessarily complete petition at the first stage. And the sort of dichotomy that the defendant says, well, if they actually filed something early, like at the first stage, that it would have gotten dismissed. No, this type of case would have been easily past the arguable standard of Hodges, that it's a very limited amount of detail, and you only have to make arguably meritorious claims, and anything counsel could have put on file in this sort of situation would have passed first stage review. And then, of course, the state comes in and say, well, yeah, but the defendant didn't even allege that he took any THC, and this happened before the federal farm bill. And so, and then all the citations in the record to the fact that the plant cannabis has maybe up to 2%. So, I mean, it wouldn't have gotten him under 5 from 6.5. So the fact is, and also in the record shows that he admitted he smoked cannabis daily. So he is smoking cannabis. He's not taking any Delta 8 that didn't exist at the time. And he essentially stipulated that he was guilty, just said that the statute was unconstitutional. So I don't see how he can win this case. It's a square peg, and there's no way that this case should really prevail. Like, he's asking for a third stage evidentiary hearing where he hasn't even met the second stage standards. So that's why it's probably dismissed. That would be the extent of my argument. I'd entertain other questions.
All right, Justice Doherty, any further questions?
None.
Thank you, Your
Justice
Honors.
Laney? Okay.
Thank you.
Ms. Yesman, your rebuttal?
Yes, thank you, Your Honors. Just briefly, first, I would like to start by addressing a refrain that the state has made throughout this oral argument, which is that we have not proven that there was Delta 8 in the system. Rather, we have shown a reasonable doubt. By saying this, the state has admitted that we have met the second stage hurdle, because we do not even need to show reasonable doubt at the second stage. According to Coleman, as we have cited in the brief, all we need to do is undermine confidence to make a substantial showing of a constitutional violation. And the state admitted multiple times that we have undermined confidence here. That alone shows that we need a third stage evidentiary hearing.
But at that hearing, is that where you're saying the additional facts need to be adduced with regard to what this defendant actually ingested or didn't ingest?
Yes, because the results, then there's a possibility that it could be put through a now accurate test. We could see the actual results, see how much Delta 8 versus Delta 9 was in his system, and actually give us certainty on the issue by which we've sown doubt on.
But he retained an expert at this second stage. That expert never opined on any of that.
The expert didn't opine on what specifically he took, because that would be beyond his scope of knowledge. But what is asserted throughout the petition, as we've been talking about, is again that Delta 8 is present in all cannabis products, in all naturally occurring cannabis plants. So because of that presence, it necessarily was there in his bloodstream in a certain amount. It was not our job at the second stage to prove that amount. It is to show uncertainty of the verdict below, which is exactly what we did. I also would like to quickly correct a scientific fact. So the state points to a part of the record that says there's only 0.1 to 2% of Delta-8 in any given plant. That is actually just one study that had a very small sample size, and in those particular plants, there was 0.1 to 2%. As is seen throughout the entirety of the scientific study, when there was a larger sample size, there is up to 10% within these cannabis plants naturally occurring. I would also like to briefly address the Farm Bill issue here. So first off, in the end, the exact nuances of where Delta-8 was on the Controlled Substance Act at the time of this incident don't have a bearing on this case, because here, Mr. Lee was charged and convicted under a statute that only criminalizes Delta-9. And as we have previously established, Delta-8 was already in THC products and has been since the beginning of time, since it is a naturally occurring isomer. To the extent that the state suggests that it could not have been in any product prior to the passage of the Farm Bill simply goes against all known science and what we have in the record here. And finally, I would like to address the argument that Mr. Lee essentially conceded at the trial level. As Your Honor pointed out, this was not a guilty plea. And perhaps even more importantly, Mr. Lee did not have available to him at that time anything saying that these tests were unreliable or that this previously distinguished and reputable Chicago-based lab was actually employing a large cover-up scheme. This was not information that was available to him at that time.
I'm sorry, what time are you referring to now, please?
At the time of the trial, I apologize. Yes, at the time of the trial, there was no information available about a cover-up scheme. So what his theory of defense and the factual basis he provided at that time made complete sense. Our whole argument is that this newly discovered evidence shines new light on the entirety of proceedings and sows doubt on the entirety, including the conviction. And that is why it should be remanded for a third stage evidentiary hearing. And I see I am running out of time. Unless your honors have any further questions, then I will rest and ask that this court please reverse and remand for a third stage evidentiary hearing.
Counsel,
Thank you
I do have one question. And I guess I just am trying to clarify as far as what is before the court with the affidavit. It seems to me somewhat, and I guess if this is where I want clarification, that there's nothing in the record that tells me they were attempting to obtain an expert before they actually received the case file from trial counsel on August 21st. And I guess that's where I have some concerns that it's really not telling us what the attorneys were doing as we evaluate that with regards to the recklessness issues and the timeline. And furthermore, specifically what occurred after those dates up until the date of filing, which I know there's the statement that, well, we got the report on the 27th and then we filed on the 29th of October. But I guess help me better understand what else is in the record that you want to point out that tells me exactly what they were doing prior to that time as far as trying to obtain an expert.
Yes, Your Honor. So in answer to that question, I would say that while we don't have some of the specific facts that perhaps you are asking to or would want to see in this record here, what we do have is counsel's assertion that he was doing everything in his power to obtain an expert to get this filed by the deadline. And in addition to that, again, although we don't have necessarily those specific facts here, we do have a very detailed timeline of the other steps that he took and why he deemed those steps to be necessary before he could file this particular petition. There also is, he includes a timeline.
At this stage, though, counsel, if he makes those more conclusory statements, you're suggesting we have to take that as true, even without any specific facts, correct?
Not if they were solely conclusory, but we do maintain that they were well pled because of the timeline that he set up here. First, about the lab's ongoing cover-up. Second, about trial counsel's inability to provide the case file until August of 2024. And in that, although perhaps it could have been made more explicit, there is an implication that a scientist could not have been hired until that case file was turned over, because there's not necessarily known what exact type of scientist do we need, what sort of expert do we need. You need the case file below to really be certain of who you need to hire to accomplish the next goal. And so, yes, that could have been made more explicit, but that is there and implied, and we do have an affidavit with that implication. We have the fact that there is a good faith assertion that the scientist hired to analyze Mr. Lee's test results did need a few months to draft a report and finalize his findings. And that does comport with the timeline that we see in the record actually for other scientific findings, such as the paper that we have on THC and how long these things sort of take. So it does comport with that. So again, I do acknowledge that it's in a few different places and maybe not laid out all linearly in the easiest manner, but it is all there. And that is enough for it to be well pled at the second stage.
Thank you.
All right. Thank you very much, counsel, both of you, for your arguments this morning. The court will take the matter under advisement and render a decision in due course. Court stands in recess at this time.
Thank you, Your Honors.